This is the Parental Alienation Speaks podcast. I'm Cheryl Mefford. In today's episode of Changing the Precedent of Parental Alienation, follow me to the Indiana Court of Appeals, where I cover Hanson versus Spolnik. In this highly contentious appeal, we'll hear whether one mother's use of parental alienation tactics towards the father justified the modification of a joint child custody arrangement. In this precedential case, Marianne Hanson challenges the trial court's modification of its joint custody decree to award sole custody of the party's minor child to Edward Spolnik Jr. Marianne had 4 issues for review for this court. Number 1, whether the evidence was sufficient to support the trial court's finding that a substantial change of circumstances had occurred which justified a modification of custody. Number 2, whether the trial court unfairly restricted visitation with her child. Number 3, whether the trial court erred in awarding Edward's attorney fees in the amount of $65,200. And number 4, whether she was erroneously held in contempt for violating the court's mutual restraining order. Here are the facts in this case that led us to this point. On March 16, 1995, Marianne and Edward's marriage was dissolved. Pursuant to the parties' dissolution agreement, the trial court awarded them joint legal and physical custody of their 4-year-old daughter. Under the terms of the agreement, Edward retained the daughter for 3 days a week and Marianne for 4 days a week. Additionally, all major decisions regarding her care, including education, extracurricular activities, and medical treatment, were to be made by both parties. In June of 1995, Marianne started taking the child to see Michelle Crane, a child psychologist, because she believed that the child was anxious and confused about the divorce and the visitation schedule. During the sessions with Crane, Marianne repeatedly indicated that she desired a modification in the child custody arrangement, stating that she suspected Edward of sexually abusing the child and that he had a long history of psych treatment. After interviewing the child psychologist Crane determined that the child was not upset by the visitation schedule and that a modification in the custody arrangement wasn't necessary at the present time. She did indicate that modification of the visitation schedule might be appropriate once the school year began, and she also wanted to talk to Edward about his alleged inappropriate behavior. However, Edward and Crane never met. On October 13, 1995, Marianne filed a petition to modify custody, claiming that Edward had violated several agreements with her regarding the child's education and attendance at church. She also claimed that Edward was completely disabled due to stress and that he improperly allowed the child to sleep in his bed. While the petition was pending, Marianne informed child psychologist Crane that Edward had exposed himself to a boy in the bathroom at the child's school and had inappropriately rubbed a medical cream on the child's vagina. She also stated that the child had told her that Edward had allowed her to shake his private parts. As a result, Crane filed a report with the Boone County Child Protective Services. Marianne also filed a similar report with regard to the same incident. However, Child Protective Services did not substantiate the allegations and subsequently closed its file on Edward. Tensions between the parties continued to grow throughout the pendency of the modification proceedings. Marianne, in the presence of the child, accused Edward of disrupting her class and making her cry. She told Edward to go to hell, indicated that he was going to get AIDS, and informed the child that she would have to be decontaminated after Edward placed his stocking cap on her head. According to Edward, the child also heard Marianne repeatedly call him Satan and accuse him of being homosexual. On February 6, 1996, Edward filed a petition for a mutual restraining order, claiming that Marianne had made numerous harassing telephone calls to him with regards to the modification proceedings and requested that the parties' communication with one another be restricted to visitation issues. The trial court granted the petition for the restraining order the next day. Edward and Marianne continued to experience difficulties in their limited communications and with the custody arrangement. In April of 1996, Edward hired a private investigator, Norman Borders, to accompany him as a witness when he exchanged his daughter at Marianne's residence because he believed Marianne would attempt to fabricate allegations against him. After Edward and Borders arrived to pick up the daughter on April 12, 1996, Marianne followed them to a local truck stop where Edward drove Borders to his car. Marianne then proceeded to photograph Borders and obtain his license plate number. Later that evening, Marianne left the following message on Edward's answering machine.
You have one unheard message.
You can play this for the judge because I would gladly be in contempt with you. You know what, buddy? You've got big-time problems. You are traumatizing that little girl, and you're going to court this week, and you'll see what's going to happen to you. And I hope you play this for Bob Saint and all your goons, because you are in big-time trouble.
End of message.
Over the next few days, Marianne left several other messages on Edward's answering machine, informing him that future exchanges of their daughter would occur at the truck stop. She also stated that she had contacted the police and that he and Borders would be arrested if they came on her property. Several days later, Marianne, Edward, and Borders met at the truck stop to exchange the daughter. Shortly after the exchange, Marianne returned to the truck stop, saw Borders, and began to follow his vehicle. In response, Borders began backing his vehicle towards Marianne's car. After blocking Marianne's car and glaring at her, Borders drove away. Shortly after, Marianne reported the incident to the police, stating that Borders looked like the Unabomber and he could have been a hitman. She was subsequently informed that Borders was a private investigator. Following the truck stop incident, Edward and Marianne exchanged the daughter in the parking lot of a local church. At the exchanges, Edward was accompanied by Borders, and pursuant to her request, Marianne was accompanied by officers from the Zionsville Police Department. During one exchange, 3 police officers arrived at the church shortly before Marianne. When Marianne drove into the parking lot, she stopped approximately 150 yards away, honked her horn, and flashed her lights. The officers then physically removed the daughter from Edward's vehicle and placed her in Marianne's car. On April 17, 1996, Edward filed a petition for contempt against Marianne, alleging that she violated the court's restraining order when she left the messages on his answering machine. At this time, as a result of numerous continuances requested by the parties and several changes of judge, the trial court had still not ruled on Marianne's petition to modify custody. However, the trial court proceeded with a contempt hearing on July 5, 1996, after which it found Marianne in contempt and ordered her to complete 8 hours of community service, apologize to Edward, and pay his attorney's fees. On July 27, 1996, Edward filed an emergency petition for modification of custody and supervised visitation. 4 days later, Marianne moved for reconsideration of the contempt finding. A hearing was conducted on both Edward's and Marianne's petitions for modification of custody in November 1996. Edward presented evidence that, prior to the parties' divorce, Marianne's 12-year-old daughter from a previous marriage had inappropriately touched their 4-year-old daughter. He then argued that Marianne had not provided adequate counseling for his stepdaughter and had failed to ensure that their daughter was protected from any further incidents with the stepdaughter. In the original trial, Marianne presented evidence that established that the stepdaughter had received counseling and had been released from further sessions. The record also indicated that Marianne had repeatedly informed counselors that the incident had been unsubstantiated. However, the Boone County Office of Family and Children specifically stated that the allegations had been substantiated. Additionally, Dr. Judy Anderson, a clinical psychologist who interviewed the stepdaughter and the daughter, specifically stated, quote, "There was inappropriate sex play between the two children," end quote. Additionally, Edward argued that Marianne had engaged in a pattern of parental alienation with their daughter that was affecting her long-term emotional and psychological needs. In support of these arguments, Edward presented the testimony of Dr. Richard Lawlor, a child psychologist. In his prior testimony, Dr. Lawlor, who was used as an expert witness in this case, testified that Marianne was causing parental alienation syndrome to occur in the child, but that it was not yet, quote, "a full-blown syndrome," end quote. He also testified that Marianne is systematically trying to convey through a denigration of the father that he's evil, dangerous, and that the child shouldn't be involved with him. He also stated, "It's extremely detrimental to be in the custody of a parent who's engaging in a pattern of alienation against the other parent," and that his research on parental alienation showed the prognosis for the child is poor once an alienation situation has developed. The success rate is almost zero, and the failure rate is almost 100% in cases like that once they get going. Dr. Lawlor admitted under oath that he is familiar with Dr. Gardner's syndrome called parental alienation syndrome and described it as a situation where you have a systematic attempt at denigration of the parent with the attempts at isolation of the child from the parent. Also, after reviewing records and reports from Child Protective Services, Michelle Crane, and several other counselors, Dr. Lawlor indicated that Marianne had not taken appropriate action in resolving the incident with the daughter and stepdaughter. He also indicated that Marianne's comments and allegations against Edward were directed at alienating the child from Edward, and that Marianne's behavior endangered the child's emotional and psychological development. In response, Marianne argued that the allegations and statements she made about Edward were either true, not made in the presence of the daughter, made in the heat of the moment, or never occurred. She also indicated that she had obtained counseling for the stepdaughter, which the stepdaughter had completed. Also, in prior original trial testimony, a court-appointed guardian ad litem noted that the 4-year-old child had been placed in, quote, "the middle of a very intense battle zone," end quote. Following the hearing, the trial court entered findings of fact and conclusions of law, determining that there had been a substantial change in circumstances which justified a modification in custody. Specifically, the court determined that Marianne had engaged in a concerted effort to destroy the relationship between Edward and the daughter since the divorce. As a result, the court awarded sole physical and legal custody of the daughter to Edward. Additionally, the court denied Marianne visitation for a period of 60 days, followed by 2 hours of supervised visitation with the daughter every 2 weeks for 3 months. After the 3 months was over, the visitation schedule would be re-evaluated. Marianne was also ordered to pay Edward's court fees in the amount of $65,200. The trial court did not address Marianne's petition for reconsideration of the contempt finding. This concludes the facts in this case that led Marianne to bring this case in front of the Indiana Court of Appeals. On August 29, 1997, Marianne Hanson filed this case with the Indiana Court of Appeals with Judges Baker, Darden, and Chasem presiding. Marianne had 4 issues for review for this court. Number 1, whether the evidence was sufficient to support the trial court's finding that a substantial change of circumstances had occurred which justified a modification of custody. The Indiana Court of Appeals concluded that the trial court did not err in modifying the custody order and therefore upheld the court's decision to award Edward sole physical and legal custody of the child. Number 2, whether the trial court unfairly restricted visitation with her child. Although concerned by the restrictive nature of the initial custody order, the Indiana Court of Appeals noted that the trial court had recently extended Marianne's visitation to 6 hours every other week and allowed for a periodic re-evaluation of the visitation schedule. Given the animosity between the parties and the trial court's movement towards more liberal visitation, the Indiana Court of Appeals voted to uphold the trial court's visitation order. Number 3, whether the trial court erred in awarding Edward's attorney fees in the amount of $65,200. Although the Indiana Court of Appeals stated that they are concerned about the need for so many attorneys and the expenditure of such a large amount of funds in custody modification proceedings, they voted to uphold the trial court's decision for Marianne to pay Edward's attorney's fees. And number 4, whether she was erroneously held in contempt for violating the court's mutual restraining order. In February 1996, the trial court entered a mutual restraining order strictly limiting Edward's and Marianne's communication to issues involving any change in visitation. The record also reveals that Marianne left a phone message on Edward's answering machine on April the 12th, 1996, informing him that he was traumatizing his daughter, he was going to court, and he was in big-time trouble. Marianne stated in her message that she would gladly be held in contempt, indicating her knowledge of the mutual restraining order. Therefore, the trial court did not abuse its discretion in determining that Marianne violated its restraining order and holding her in contempt. Therefore, the Indiana Court of Appeals upholds the trial court's decision to hold Marianne in contempt. Sadly, just 7 years after winning at the Indiana Court of Appeals, Edward Spolnik passed away. He was 56 years old. This concludes the journey to the Indiana Court of Appeals, Hanson versus Spolnik. I'm Cheryl Mefford. If you found this information helpful, please like and subscribe to my channel and go to ParentalAlienationSpeaks.com to learn more about our story. I'm Cheryl Mefford, and I'm fighting for childhoods.